Sure, Mark Jessup and Skip Robinson there. No, I see them.
The Honorable Supreme Court of the State of Illinois.
Marshal, the Illinois Supreme Court is convened.
Oyez, oyez, oyez. The Illinois Supreme Court is convened.
Before I begin the first case, I would like to comment on the significance of today's proceedings. It is difficult to fully comprehend just how dramatically our reality has changed here in Illinois, throughout the United States, and across the globe. Because of the unprecedented crisis created by the novel coronavirus, commonly known as COVID-19, as a result of the coronavirus, our entire court system has been challenged to discover new ways to provide access to justice while still maintaining everyone's health and safety. Today, you are pioneers. You have the unique honor of being the first to argue before the Illinois Supreme Court remotely. On behalf of myself and my colleagues of the Illinois Supreme Court, I thank you for your adaptability and cooperation. Together, we will get through this crisis. We extend our best wishes to you and that of your families to remain healthy. The first case on the call of the docket is agenda number 12406, People of the State of Illinois versus Ashanti Lusby. Ms. Bendick, please begin.
Thank you. Good morning, and may it please the court. My name is Leah Bendick from the Illinois Attorney General's Office on behalf of the people. This court should reverse the judgment of the appellate court, which erred in 3 ways. First, by addressing the merits of whether defendant should be given leave to file his successive post-conviction petition. Second, in finding that defendant's sentence violated the 8th Amendment. And third, by remanding the matter back for resentencing rather than further post-conviction proceedings upon finding that 8th Amendment error. My plan this morning is to begin with the first and third issues together, which similarly concern the appellate court's remedial authority. And then hopefully I can spend the bulk of my time on the second issue, the merits of the 8th Amendment claim. Regarding the first issue, in People versus Bailey, this court held that it is error for the state to participate on proceedings for a defendant's motion for leave to file a successive post-conviction petition. In recognizing this error, this court relied most heavily on its prior case of People versus Galtney, which had held that it was error for the state to participate in proceedings in the analogous situation of first stage summary review of an initial post-conviction petition. However, in Bailey, this court did not address the appellate court's remedial authority in remedying a Bailey error, and an appellate court split has developed since Bailey on if and when remand is appropriate. Now, it's only logical because this court in Bailey followed Galtney in recognizing the error that this court should consult Galtney on this remedial question. And in Galtney, this court held that unless the circuit court invited the state's participation or relied upon the state's influence or input, that the matter must be remanded back for that first stage review to happen without state participation. Defendant took the same position below in the appellate court, and this court should provide that guidance to the appellate court for future cases following Galtney in this narrow circumstance of there both being a Bailey error and one in which the state influenced the circuit court's judgment on that question. And turning to the third issue, there's a second remedial question posed in this case, because once the appellate court reached the merits of the leave to file question, the Eighth Amendment issue, upon finding an error, the appellate court remedied it by remanding for resentencing. But this poses a question under Supreme Court Rule 615B, which addresses the powers, the remedial authority of the appellate court. Under 615B1, the reviewing court is empowered to affirm, reverse, or modify the judgment below. And here the judgment below was the denial of leave to file. Now that is a more preliminary question than the relief that the appellate court actually provided, which was resentencing. In other words, the appellate court provided post-conviction relief. The appellate court seemed to acknowledge that it might have been overstepping, acknowledging that ordinarily when it's reversing leave to file, it should remand the matter back. But the majority cited other Eighth Amendment appellate court cases that had similarly provided resentencing, even though the case came up on appeal in this preliminary posture. This court in People versus Buffer considered an analogous situation because in Buffer, his initial post-conviction petition had been summarily dismissed at the first stage. The appellate court reversed and ordered resentencing. And the people briefed this same procedural question before this court. This court also ordered resentencing and explained that there was no need for third stage proceedings because for this type of Eighth Amendment question, there is no need for factual development through live testimony of witnesses at an evidentiary hearing. But what this court overlooked in Buffer was the importance of the second stage. And this actually relates to the Bailey error issue as well. The reason behind the remand in Galtney, and that this court should do that for Bailey error as well, is recognition that in most cases, petitioners do not have counsel at that initial stage, and that it would be inequitable to allow the state to participate at that proceeding when the petitioner does not have counsel. And that emphasizes the fact that it is not until the second stage that the state gets an opportunity to raise potential procedural defaults. And there can be procedural defaults even in Eighth Amendment cases. The opening brief has provided citations to both Illinois cases and federal cases that have found Miller Eighth Amendment claims to be time barred. There also could be res judicata bars that come up in some of these cases. And so it's important that post-conviction relief not be provided before the second stage has ever occurred. And it's not only for the state side of things, it's important to protect the defendant's rights as well. Because again, in most cases, the defendant will not have counsel until the second stage. It is very possible that counsel will look at the pro se petition and find not only an Eighth Amendment claim, but a kernel of a trial error that if counsel can flesh it out in an amended petition, might entitle the defendant to relief not only on his sentence, but perhaps on his conviction. So it is, yes.
Can I ask a question? Why can't these defenses be raised on review where everybody's represented by counsel and as Buffer and Holman state, we're looking at the cold record?
Well, it's again, because what is the judgment under review? It's only whether it was appropriate to deny leave to file. And as to the leave to file question, the only concern is whether there's that cause and prejudice. That's why it hasn't come out in the briefing in this case. And there's no reason for the parties to think that they have to brief that issue of time bar, of res judicata, when really the judgment under review is just whether the defendant has made a prima facie showing of cause and prejudice. That is the scope of the case. That is the whole point under 615B that kind of puts the parameters on the appropriate content of the case. It could be in some cases that this court has the information it needs to make that determination. But the point is that the state has never had that opportunity in this case to have briefed the procedural default. There is a potential time bar argument in this case, for example, given the fact that the petition was filed almost 2.5 years after Miller was released. And so in the end, if this court is concerned about judicial economy, when it does go back, the proceedings could be very prompt. The state might not choose to raise procedural defenses or might. And then the third stage won't have to include the testimony of witnesses. And so the matter can be pretty promptly resolved. But it's important to follow 615B Although the state acknowledges that this court's remedial authority is broader than the appellate courts because of its state constitutionally granted broad supervisory authority. And so this court in Bailey and this court in Buffer could reach those questions. But what is important is for this court to provide guidance to the appellate court, which does not have that broad authority and should act within the scope of both Rule 615B and within the scope of the framework of the Post-Conviction Hearing Act to ensure that relief is not granted when the second stage has never occurred. And so if there are no further questions on that point, I would like to turn to the Eighth Amendment question. This Eighth Amendment question is pretty straightforward in a sense because of the many cases that have already come before. Of course, we have Miller and Montgomery, and as this court very aptly summarized in Buffer last year, the Miller and Montgomery Eighth Amendment analysis has both a procedural component and a substantive component. The procedural component is that the sentencer must have considered youth and attendant characteristics in weighing what sentence should be imposed. And as this court in Holman clarified, what that entails is the consideration of the 5 factors from Miller that this court listed in Holman that sort of provides more detail about what that means. As Buffer correctly summarized, there's also the substantive component that the sentence imposed must be proportionate. And that turns in part in the juvenile offender contexts on the sentencing judge having made a determination about the nature of the crimes. Because on one hand, if the crimes involve transient immaturity, then the Eighth Amendment bars categorically a life sentence. Whereas if the crimes reflect, and the long phrase, which I'll quote from Holman, quote, showed irretrievable depravity, permanent incorrigibility, or irreparable corruption beyond the possibility of rehabilitation, which I'll shorthand as irretrievable depravity. If it's in that category, the crimes, then there is a potential to impose a life sentence. Now, this case is narrow because we know from Holman that this analysis applies to discretionary sentences. And we know from Reyes and we know from Buffer that the sentence here was de facto life. So the question then is applying, or I should say the most important case for evaluating the Eighth Amendment here is the Holman case, because Holman, just like this one, was evaluating the propriety of the sentence that was imposed before Miller. And this court explained and provided an analytical framework for evaluating a case like Holman or like this one, that the whole record should be examined to pull out the parts that are relevant to the Miller factor evidence, that are relevant to the seriousness of the crimes and the defendant's background. And all of that should be weighed to determine whether the sentence imposed is proportionate and whether the sentencer followed those benchmarks of considering that Miller evidence and making that determination of whether the crimes were irretrievably depraved.
Ms. Bendix, may I ask a question?
Sure.
This case is slightly different factually, I think, from Holman, but for some of these other cases. Here, the defendant was 16 years old when he committed this murder. But he was not charged for 5 years later, and actually at sentencing, he was 22 years old. The court had before it the criminal history of the defendant in the interim, that he was convicted of 3 separate violent felonies, 2 misdemeanors. He was placed on probation and violated his probation. He was placed in custody, and upon his parole, the day of his parole ending, committed another felony. And then while he was in custody, awaiting trial on the murder, committed another violent felony in the jail. Miller is concerned about juveniles and young people and how they change. Does it matter here that the person that the judge was sentencing was 22 years old and not a juvenile?
Well, certainly you're right. Everything you've summarized is accurate about this record. And I would say that as a result, this case presents even more information than the average case about that 5th Miller factor, which is the defendant's prospects for rehabilitation. because we have a longer period of time to look at in that interim 5+ years. It's certainly appropriate under Holman, Miller, Montgomery to look at what we know about the defendant up into the point of sentencing. And so, yes, I think that's appropriate for that to be weighed. It provides even more detail about his prospects for rehabilitation. And so, yes, that's certainly appropriate to consider in this case. And it was something that was detailed accurately in the pre-sentence investigation report that was before the sentencing judge. And indeed, we know here that if we're looking for those two benchmarks along the way that Buffer highlighted as being part of this, in summarizing Miller and Montgomery, were those Miller factors considered? Was that finding of irretrievable depravity made? There are several indications in this record to put this court's mind at ease that there is no Eighth Amendment problem. What the appellate court majority here stressed was the procedural component. We know from paragraph 29 of the appellate court's decision that it viewed these crimes as heinous, so it wasn't really concerned with the substantive component. But at 27 and 28, the majority concluded that there was no indication in the record that the Miller factor evidence had been considered, particularly because, unlike Holman, it concluded there was no indication that the PSI had been, no explicit confirmation the PSI had been considered. The problem with that is both factual and legal. You can see at page 10 of the appendix of the opening brief that the very first thing the sentencing judge said when the sentencing hearing began was, "I have considered the PSI." So there was that explicit confirmation. But even putting that aside, the potential importance of this case is to explore whether the appellate majority was even right to look for that kind of explicit confirmation. And this court should confirm that it was not appropriate. Holman did not purport to put additional benchmarks into this sort of procedural obstacles into this analysis. All that Holman did was to look at the record and summarize the parts of the record relevant both to the Miller factors and to the irretrievable depravity determination. This court in Holman required all 5 Miller factors to be considered, but in Holman, as in this case, each and every one of those Miller factors weren't expressly mentioned by the sentencing judge at the sentencing hearing. And yet in Holman, this court did not find any kind of Eighth Amendment deficiency. We can see in Montgomery as well, the US Supreme Court was reluctant to impose any additional sort of express factual finding requirements into this analysis. And this court should, in fact, confirm that all Holman did was highlight the relevant parts of the record. Every case is going to be different and is going to have different facts. So none of these particular characteristics of Holman should have determinative constitutional significance. Now, we also know from this case, or I should say in this area of the law, that there's not any need to be concerned for an express confirmation that the PSI was considered, because there are at least 2 statutory provisions in Illinois that require the sentencing judge to consider a PSI before imposing sentence. We, for decades in Illinois, have operated under non-controversial presumptions that a judge is going to consider the evidence before him or her, that the judge is going to follow the law, including this requirement that the PSI be considered, and that a sentencing judge is not required to list each and every statutory aggravator, statutory mitigator, or even non-statutory aggravating or mitigating factor in order to explain in such microscopic detail exactly what was weighed in arriving at that sentence. There is no need to import that level of micromanaging into juvenile offending cases, and this court did not in Holman. This court did not require each of the Miller factors to have been expressly addressed in the sentencing transcripts. And indeed, even putting that aside, I mean, this court should affirm that for future cases. That would be important for this court to clarify. But in this case, there's even less concern because we have all 5 of the Miller factors addressed by parts of the record. This is detailed at pages 22 and 23 of the opening brief. We know that the 1st and 5th Miller factors were specifically addressed in the sentencing transcripts. We know the trial record addresses the 3rd, and the PSI contains the 2nd and 4th. And so we have that procedural compliance. As for the substantive part of it, we know that the sentencing judge found irretrievable depravity. We have both a special verdict form from the jury, finding that these crimes were brutal and heinous and indicative of wanton cruelty. We have the sentencing judge actually describing these crimes as depraved, and for good reason. I mean, so because of that, we have that finding in the record. And the only question then is this proportionate? We know from the trial record the brutality of these crimes here. We know the victim, Jennifer, was brutally sexually assaulted at knife point. We know she was executed. We know, as Justice Tice summarized, that the defendant had an ongoing criminal record before sentencing. And we know that he came from a pretty stable family home life. We know he got his GED. He did not have mental disabilities or I should say brain injury, as Holman did, for example. And so weighing this all together in light of the brutality of these crimes, this court should confirm that this was a proportionate sentence. It is important for future cases that to the extent this court is concerned about the proportionality of the sentence, that is the ultimate determination that can be made in each and every case, which will be different on its facts. There is no need to import additional sort of subsidiary obstacles along the way, looking for express findings on the record for this procedural benchmark or the substantive benchmark, because the court ultimately still has that question of finding whether the sentence was proportionate. And that guidance that Holman is just an example of employing that analytical framework should be confirmed here. And this court should provide that guidance on the remedial question as well as to the Bailey error and these Eighth Amendment cases that come up in a very.
May I ask you a question here about what is the precise issue before us? As we all know, the United States Supreme Court is very interested in this issue. And since the Lusby case has been pending, the court has taken a case called Jones versus Mississippi. And the specific issue there is whether the Eighth Amendment requires the sentencing authority to make a finding that a juvenile is permanently incorrigible before imposing a sentence of life without parole. It sounds like the United States Supreme Court has pending before it almost the precise question that we have here.
It's a very similar point. It's about a finding of the irretrievable depravity, whereas the appellate court in this case was hung up on whether there needs to be an express finding on the PSI. This court is certainly welcome, if I may finish briefly answering, thank you. This court is certainly welcome to wait for this court's guidance, although that may be several months down the road, given the fact that in Montgomery, the US Supreme Court already expressly stated there is no need for an express factual finding on the record. I think that's an initial showing that the court is leaning in that direction, which Holman follows completely. I think it's very possible, as can be seen in the cert petition in Jones, that there are other states in this country that have not been as competent in enforcing this Eighth Amendment analysis as the Illinois courts have. And so the fact that the court is taking another case to provide more guidance doesn't call into question necessarily what's happening in Illinois. It's probably calling into question what's happening in other states, but this court is free to either go ahead now or wait for the court's further guidance in Jones.
Thank you, Ms. Bendick. Ms.
Thank you.
Nall, you may proceed. You may proceed.
Thank you. May it please the court, counsel. My name is Deborah Nall from the Office of the State Appellate Defender, and I represent the appellee Ashanti Lusby. As illustrated by the historic nature of today's argument, our world has changed dramatically since 2002, when Ashanti Lusby was consigned to die in prison for offenses that took place when he was a 16-year-old boy. 2002 was a full decade before Miller held that life sentences for juvenile offenders should be the exception rather than the rule. And contrary to the state's assertion, Miller completely upended traditional presumptions in the context of juvenile sentencing law. So we now know that a juvenile who is not himself found to be permanently incorrigible or irreparably corrupt is constitutionally ineligible for a sentence of life without parole, even if he has committed terribly serious and even depraved crimes. Here, Mr. Lusby raised two issues on appeal. a procedural error under this court's decision in Bailey, and a substantive Eighth Amendment error under Miller and its progeny. This court should affirm because the appellate court correctly followed this court's precedent by remanding for resentencing, where Lusby established a constitutional error that required no additional factual development. I plan to begin with the procedural post-conviction questions and then turn to the substantive Eighth Amendment issue. Lusby raised two record-based issues. So remand would have been required on the Bailey error if the appellate court had not found an Eighth Amendment violation, because Lusby alleged cause and prejudice. And importantly, the state in this case has conceded cause. And as this court said in People versus Beauclair in 2002, if a petitioner can demonstrate that an untimely filing was not due to his culpable negligence, there is no time limit within which he must file a post-conviction petition. So the first stage timeliness concerns are subsumed by the much more difficult successive petition culpable negligence standard. So resentencing was actually the correct remedy under this court's precedent because there are no procedural defenses where the state conceded cause and where Lusby's Eighth Amendment claim requires no factual development, where Holman limited the scope of review to the cold record. Regarding the leave to file question, the state relies on cases in which the Bailey error was the only issue raised on appeal. And so in those types of proceedings, it's true that a new leave to file proceeding is the only fair relief, where, because it would violate fundamental fairness to allow the state to have input at that stage, where, as counsel said, the defendant is without counsel. But resentencing is the correct remedy because in this case where there's a substantive error, because there's, again, no need for further factual development on the substantive point. And so direct advancement for resentencing furthers both the interest of justice as well as the Post-Conviction Act's purpose, which is providing a statutory mechanism for incarcerated defendants to assert that they have been unconstitutionally deprived of their liberty. Turning to the Eighth Amendment issue, again, the state concedes that Mr. Lusby showed cause for leave to file a successive petition where Miller was decided a decade after he was sentenced to life imprisonment for this offense that happened when he was a young teenager. Therefore, the only issue before this court is prejudice. And as the appellate court correctly held, Lusby established prejudice under this court's precedent because review of the cold record shows that the sentencing court did not comply with Miller. And this is not surprising because a 2002 court had no way to predict the advances in social science that led to Miller's holding that juvenile offenders may not be sentenced to life imprisonment unless the sentencing court has first considered the specific circumstances of their youth and mitigation, and then found them to be one of those rare juvenile offenders so irretrievably depraved as to be beyond redemption. And importantly, it is not about the nature of the offense, it is about the offender. And this is so because as a class, all juvenile offenders are categorically less culpable than adults, even if they've committed terrible crimes. And that's because, as this court explicitly recognized in Holman, the diminished culpability of juvenile defendants is not crime specific. But this was not the law in 2002. In 2002, the law was the opposite. The nature of the offense subsumed all other concerns. Therefore, we cannot presume both that the sentencing court complied with the 2002 law and that it complied with Miller. Instead, as this court held in Holman, the original sentencing hearing must be viewed through the lens of Miller and its progeny. Here, the record shows that sentencing focused on the offense and the decedent. Mr. Lusby was little more than a blank screen on which the state projected basically a monster. He was shackled throughout trial, even though there was no finding about his actual dangerousness. And then everything was about the offense, and really it was about Jennifer Happ. defense counsel did not point to any evidence in mitigation, any evidence or to Lusby's individual background as mitigation. And the state then used the PSI as pure aggravation, which again was in accordance with 2002 law. So any presumption that the trial court complied with Miller at sentencing is simply nonsensical, because after Miller, factors that were then properly considered as pure aggravation are now often better understood as mitigation. So for example, here, the sentencing judge did not consider the probation officer's conclusion that Lusby was capable of rehabilitation when it found there was no mitigation. And the court's failure to consider this factor by itself requires remand for resentencing, because this evidence establishes that Lusby was not one of those rare offenders who may be legally sentenced to life without parole for a crime committed as a juvenile. And second,
Can I ask you?
yes.
Didn't the appellate court majority rely fairly heavily on the fact that the trial court did not consider the PSI, which was in fact not borne out by the record?
The dissent said that the dissent made it seem like that was the deciding factor. I don't actually read the appellate court's decision that way. I think what the appellate court said is that, and I'm going to just grab my copy of the decision. Sorry, I can't find it. What the appellate court was concerned with was whether the sentencing court had properly considered the evidence of Lusby's individual circumstances in mitigation. So again, it's looking at the offense through this lens that we now have of Miller, instead of what things were then, which is where the offense, Illinois has long had a history of being concerned with juveniles. But in Mr. Lusby's sentencing and Mr. Lusby's trial, the concession was that he was ineligible for the death penalty. So things have changed now where he, if he were sentenced today, there would be things brought out. It would be very similar to a death penalty sentencing hearing. And so the appellate court was saying that the sentencing judge in 2002 did not look to the mitigating factors in the PSI in the way that we now know needed to happen.
I ask you a question on that. You've said very clearly that jurisprudence about sentencing, especially sentencing juveniles, there's been a sea change over time. And yet we are directed by Montgomery to examine the trial court, the sentencing courts, the sentencing hearing, how it was provided, what the sentencing court took into consideration. But as we all know, the court in this case, and probably no other case, used the term youth and its attendant characteristics because that language didn't come up in Miller until 10 years after this hearing. So you seem to be arguing that because there's been this sea change, there could never be a case where prior to Miller, before the Supreme Court instructed that sentencing courts look at youth through this lens, that there could never be a case because that's not what the judge was considering at the time. Is that what you're saying?
That is not what I'm saying, Your Honor. And in fact, Holman presents an example of a case in which, even though that wasn't required at the time, the parties did litigate that sentencing hearing very much like a death penalty hearing. And so there was copious amounts of information about who that defendant was, about who Mr. Holman was, that was introduced. And so when this court reviewed that sentencing hearing, it was very different from the other end of the spectrum, Buffer, Dimitri Buffer's case, where there was so little information introduced, which was much more standard, in accordance with the law at the time. In my case, Mr. Lusby's sentencing hearing was much more like Buffer's hearing than it was like Holman's hearing. So I am not at all arguing that there can never be a situation. I do think that under Montgomery, it would be rare because it's only the rare juvenile defendant who is permanently incorrigible at a young age. And regarding your point, Justice Tice, about the fact that Mr. Lusby was 22 at the time of sentencing, again, that was, defense counsel didn't really push back at all. But when we look at this now through the lens of what we now understand about trauma and the neuroscience of juvenile brains, the offenses are actually very much, they take a trajectory. I mean, obviously they're all serious, but there was aggravated discharge of a firearm in 1994. There was this case in 1996. And the facts of the record actually do show that there's some question about what actually happened. So I'll leave that aside for a moment. But then there was robbery in 1998, which is much less serious than what happened in this case. Resisting a peace officer in 2001, again, not great, but less serious than robbery and much less serious than what happened in this case. And then in 2002, while Mr. Lusby was awaiting sentencing after having been found guilty, there was a jail fight, which, again, I am not defending that action, but it is showing a trajectory toward something that is not a depraved monster. It's showing someone who is from a troubled background and who was caught up. I mean, we know that he was, involved in gang activity. We also know that from the things we know now about changes in juvenile brain development, that it's not unexpected that young people who are from these difficult backgrounds are involved in criminal activity. And so when we look at this through the lens of Miller, it actually evidences a capacity for rehabilitation, which is, again, underscored by the probation officer's finding in this case that Mr. Lusby could benefit from counseling. And so to presume in this case that the trial court, who didn't have any of this information about what we now know, and was focused entirely on how terrible this offense was, it's an awful crime, and it was very much affected the community. And Jennifer Happ left a lot of people behind, and they came out in force to speak about the effect on them. Defense counsel pointed to, he didn't bring anyone in to talk about Mr. Lusby because he didn't know that that was going to matter. So given all these circumstances, we cannot feel secure that the Eighth Amendment was complied with in this case. It's much more like Buffer than it is like Holman. And I'm trying to...
Counsel, can you comment on opposing counsel's statement that evidence of all five Miller factors was addressed in the record?
Yes, Your Honor. I agree that there was some evidence of all factors. I do not agree that they were considered in the way they're required to be considered under Miller, which is that they need to be considered as mitigation. So here, those factors, if considered at all, were considered purely as aggravation. For example, Mr. Lusby's home life, this record contains very little, but when I look at it through the lens of Miller, I see that his family, two of his sisters had been involved in the criminal justice system. That's not typical for people who, don't have, to me, that suggests that he did have a troubled background. He also was thrown out of school in the 10th grade for gangbanging. In 2002, that was pure aggravation. Now we know that gangbanging involves peer pressure, and that peer pressure is one of the emblematic things that leads youth to behave in ways that are not showing that they're irritably depraved, but rather that they're suffering from an inability to make reasoned choices. There's also the involvement in the offense. The record shows Lusby maintained his innocence, but at trial, his ex-girlfriend testified that Lusby was out with two friends that night, and they were looking to steal a car when they came upon the decedent's open garage and door. Things went terribly, terribly wrong. Lusby testified at trial about, he made up a story, or he testified in a way that the prosecutor characterized as a 16-year-old's fantasy. And again, I think that's really telling when we look at that today through the lens of Miller, because what it reflects is not that there was some sort of considered plan from the mind of an irretrievably depraved monster, but behavior that's emblematic of a troubled child, a young boy. And I'm trying to, let me just make sure I've covered all of the, so there's family. Yeah, another thing with the family is that Lusby told the probation officer he had a good relationship with his parents. They visited him often in jail, but in fact, the jail log revealed no visits. The probation officer was unable to reach his family. So there's a disconnect there. And then importantly, the judge did consider Lusby's chronological age at the time of the offense, as well as the very general principle that kids often make poor choices. And in this case, he made a choice that could never be taken back. But as this court held in Holman, consideration of generally mitigating circumstances related to a juvenile's youth is not enough to comply with Miller. And that is so because adolescence is marked by this transient rashness, this proclivity for risk, and an inability to assess consequences. All factors that should mitigate punishment for a juvenile offender, but were never properly considered in that light in this case. There's also the evidence of Lusby's daily marijuana habit, and which we now know, again, you know, the effect of drugs can often be mitigating now. Back in 2002, it never was. And I think that's all of the factors. So the short answer is I do agree with counsel that there is some evidence in the record. I do not agree that it was properly considered as mitigation. In Montgomery versus Alabama, the United States Supreme Court acknowledged that sentencers might encounter the rare juvenile offender who exhibits such irretrievable depravity that rehabilitation is impossible and life without parole is justified. But the court also promised that the opportunity for release will be afforded to those who demonstrate the truth of Miller's central intuition, which is that even the children who commit even heinous crimes are capable of change. The circuit court in this case should have granted leave to file the Miller claim because the record shows that Lusby was capable of rehabilitation. And the sentencing court did not find him himself to be one of those rare, irretrievably depraved juvenile offenders for whom life imprisonment is justified. And just quickly to be very clear, we are not arguing that there needs to be a specific finding. Miller made it very clear that there does not need to be a specific finding. We are arguing that there needs to be a showing in the record that the offense was considered through the lens of who the person was. So there does need to be a finding that that person, with no magic words, but something to give this court confidence that this person was carefully considered before they were just consigned to die in prison.
Ms. Knoll,
Yes,
your time is up.
thank you very much. I'm sorry. Thank you.
Ms. Bendick, you could proceed.
Thank you, Your Honor. There are two things going on at the same time in this case. There's the importance of this court providing guidance for future cases, and then there is this case in particular. It's important what counsel actually just said, that she is not saying, she's not agreeing with the appellate court where at paragraph 28, there needs to be that explicit finding that the PSI was considered. I think that's important because it corresponds with Montgomery in that regard. But when counsel is saying that there needs to be some verification that everything was viewed in the lens of Miller and Montgomery, I would echo Justice Tice's concerns that she is in effect trying to limit Holman as being a one-off, the only case that could ever comply, essentially. And instead, though, if you look at this case side by side with Holman, it's remarkably indistinguishable in the sense that, as counsel again agreed, there is evidence in the record regarding all of the Miller factors. And when Holman at paragraph 48 went through the 5 Miller factors, some of those Miller factors the boxes were checked in the sense just because there was evidence on that fact contained in the PSI. That is true in this case. And so counsel hasn't really explained what would confirm to her satisfaction that these factors are viewed appropriately. But I would instead just point this court to Holman, because Holman already looked at a pre-Miller case, and when those Miller factors are addressed in the record, ultimately that sentence in that case was upheld. It's important to look then at this case in particular for compliance. One thing I don't think I had a chance to mention in my opening was the fact that not only was there what we have in the sentencing transcripts and in the PSI, there's also the fact that defense counsel here filed a motion to reconsider sentence, where his particular argument was, Judge, reconsider the sentence you imposed and particularly consider my client's youth and his potential for rehabilitation. Once again, the trial judge considered that argument, but looked at the entire trial record, looked at the law, and reaffirmed that he was sticking with this de facto life sentence. Because of that, there's no doubt in this case that the procedural component was complied with here. As for the substantive component, there still is room then for reviewing courts to ultimately decide whether the sentence is proportionate. But it's important for this court to provide that guidance and not require sort of these preliminary, subsidiary, additional steps along the way about, oh, we need to have this confirmation that the evidence was viewed through the lens of Miller, even in these pre-Miller cases. It's hard for me to understand what that would look like in these pre-Miller cases. And really, in effect, Holman already rejected that notion by affirming the sentence in that case. Now, as for some more of the particular points in this case that counsel highlighted, I need to disagree with some of her characterizations of the record. She pointed out defendant's sisters, for example, to try to talk about his home life. Defendant's sisters each committed 1 misdemeanor, but they both occurred after the crimes here. So there's no reason to weigh that in terms of looking at defendant's commission of this crime. The fact that perhaps the father was a bit absent in defendant's life, I don't know that there needs to be inordinate weight given to the fact that there was perhaps a single parent household involved. And as for comparing how much evidence came out at the Holman sentencing hearing versus here, that was a very different case. And that actually was mostly related to the fact that there were psychological experts providing guidance on Holman's mental disabilities and the fact that he had organic brain damage and trying to characterize how that affected him. Every case isn't going to involve that. And in fact, that would seem to be mitigating evidence, and yet Holman's sentence was ultimately upheld. As for the point that defendants or opposing counsel made about the ex-girlfriend, the only thing that the trial record says is that the ex-girlfriend said that in early February, and she didn't know the exact date, she remembered this time when he went out with his friends. It is not clear that her memory links up to the particular date that this crime occurred. Instead, what we have is defendant's own testimony about what happened here was that he was a sole offender. Yes, he might have been a gang member earlier in life, but there's no indication that there was any kind of gang peer pressure involved in the commission of this offense in particular, which does distinguish this case from Buffer, for example, which did involve some gang peer pressure. And it is important that Buffer, comparing Buffer to this case, Buffer had no priors in his background. And yes, there were additional offenses by defendant, as we've already addressed here. Now let's see, I'm trying to look if there's anything else I need to cover. I guess really what I want to get back to is the importance of this case can be for this court to clarify what it meant in Holman. Holman, again, looked through the record, highlighted the specific components of the record that went to both the Miller factors and to the nature of the crimes. It's important for this court to emphasize what it appears from the Holman opinion itself, that none of these particular features of Holman get constitutional significance. Yes, there was a line in the PSI in Holman's case about his rehabilitative potential, and opposing counsel here is trying to place great significance in a line from the PSI. There's no requirement under Illinois law or under the 8th Amendment that the sentencing judge agree with the probation officer's opinion on that specific matter, or even that the PSI contain any information on that whatsoever. So again, every case is going to be different. We have, in this case, ample reason to conclude that these benchmarks have been met in terms of the Miller factor-related evidence being considered. There's no doubt that the sentencing judge made the finding that the crimes here reflected irretrievable depravity. It's important to remember, and even in Buffer, this court reaffirmed at paragraph 24, it's not looking at defendant as an individual, it's looking at the crimes. That is a direct quote from Miller that Buffer has quoted as well, that Montgomery quoted. It's through the line of all of these cases, that in making that determination, the question is whether the crimes reflected transient immaturity or irretrievable depravity, given the brutal and heinous finding by the jury, given the fact that the judge, even pre-Miller, termed these crimes to be depraved. There is no doubt that that determination was made below. And so if there's any room for this court to review the constitutionality of the sentence, it's not on those benchmarks. It's not about the procedural component or the irretrievable depravity component. It only comes down to that ultimate question: does this court agree that the sentence was proportionate? And but it should provide that guidance for future cases, that there are not extra obstacles that need to be imposed along the way for there to be 8th Amendment compliance. And so if there are no further questions, we would ask that the circuit court's judgment be affirmed and the appellate court's judgment be reversed. Thank you.
Thank you. Case number 124046, People of the State of Illinois versus Ashanti Lusby, is taken under advisement as agenda number 1. Ms. Bendick and Ms. Knoll, thank you very much for participating in today's remote hearing. Thank you.